Ministry of National Security, although those names are set out under the section also present. The reason for the proposal is to have in the body of the minutes those persons, since they are referred to later on in the in other paragraphs. Madam Clerk, may I hear from you what the revised sentence or sentences would read?
I had not revised it previously. I would now be doing it live, and I'm not sure whether you would want me to do that, because I'd have to look at it again to decide where to put that part of it. Or it could simply read, the persons present were Miss Shante Booth, Senior Assistant Attorney General, Ms. Sandra Brown, Assigned Director, Citizenship Unit, and Mr. Howard Palmer, Policy Manager, Border Security and Affairs.
Yes, I think that would suffice. Thank you. Right? Citizenship by descent or marriage, paragraphs. Right, if there is no other correction to page 2, we go to page 3. The penultimate paragraph, which commences, Mr. Palmer also indicate. I'm proposing that the order of the words be rearranged. So the sentence currently reads, Mr. Palmer also indicated that a Jamaican citizen who committed heinous crimes worthy of deportation in another country had the right to invoke his or her Jamaican citizenship. Just to put in another country after crimes. So Mr. Palmer also indicated that a Jamaican citizen who committed heinous crimes in another country and I don't know if worthy of deportation, if worthy is the choice of word there. Perhaps liable to deportation. All right. Any other amendment to page 3? If there is none, we can go to page 4. Page 4 is the same. 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 Page 4 is the same the paragraph which commences the chairman later summarized the ministry's position. I just ask that that be amended to read, the chairman later summarized her understanding of the ministry's position on the issue. All right, if there is the paragraph commencing, Mr. Brown asked whether the ministry had considered having the IRCCA. I ask that the sentence which commences the chairman noted be revised as follows. The chairman pointed out that once the Constitution was amended, any law that was inconsistent with it would be void to the extent of the inconsistency. Therefore, the ministry would have to consider the nature and extent of any change that would be required for conformity. Madam Clerk, did you get that?
I did, Madam Chair.
Can you just repeat it for me?
The chairman pointed out that once the Constitution was amended, any law that was inconsistent with it would be void to the extent of the inconsistency. Therefore, the ministry would have to consider the nature and extent of any change that would be required for consistency.
Very well. Thank you. The other sentence, which says she added that recognition of this reality had informed the decision to adopt a phased approach to the constitution process to minimize disruption to the system and processes that would be affected by it. I'm proposing that that sentence be amended to read. Just a minute. Right. So she added that changes made would have to be implemented. And that the decision to adopt a phased approach took that into consideration. Right? Madam Clerk, is it an error? The realms, the use of realms, is it to be pluralized or is it just realm, Commonwealth realm?
I believe they do say realms, but I would have to verify and to get back to you on it.
Right. It's Commonwealth realm without the S. Right? Please correct that. If there is no other correction to page 4, we go to page 5.
What it is?
Just clarify the thought that you captured. The ministry would like cases.
Right. Okay, so the previous sentence explained was where it was explained that if there was an entitlement to citizenship, a person who was denied, if the claim was made by a person who had no condition. Okay, so it was where I'm sorry, just let me look at that for a second. Right. So in the previous sentence, it was stated that where a person who claimed to be entitled to citizenship only sought to claim that citizenship where they were to be deported, there should be a discretion for that application to be refused. Now, the following sentence is where I stated that Mr. Palmer concurred in that he agreed that it should be treated in this manner. And he also said, where I have adding that, the ministry would like cases where an applicant was not being deported, but his or her police record suggested a public safety threat to be treated similarly, is that where, in cases where deportation was not at issue, but the person's police record suggested that they would pose a threat to Jamaica,
All right.
those cases
May I
should also
suggest
be
that the
done.
sentence be revised to read
Sure.
that he requested, instead of he would like cases, he requested that cases where an applicant was not being deported, but his or her police record suggested a public safety threat, be treated similarly. And instead of the chairman stated, may I ask that you substitute with inquired whether the ministry was seeking a carve-out.
Will do, Chair.
Thank you. Any amendment to the paragraphs under the heading appeals?
Excuse me, Madam Chair.
Yes.
I did the checks that I said I would do. I went to the www.royaluk website, and it is said that the Queen is head of state of 14 other countries. In these countries, which are often referred to as realms, the constitutional functions of the Crown are exercised on the advice of local ministers.
Right. My understanding is that when it is used without Commonwealth, Commonwealth realm or the realms. But I stand corrected.
Okay.
Any other correction to page 5? Right, we go to page 6. All right, if there is no amendment to page 6, we go to page 7. If there is no correction to page 7, we go to page 8. All right. There is no amendment to page 8. Will someone move for the confirmation of the minutes as corrected?
So moved, Madam Chair.
Thank you. Seconded by?
Seconded.
Thank you. Any matter arising?
Madam Chair,
Yes.
we did indicate on the last occasion, and it's captured in the minutes, that we would look at what further input we needed from the individuals and entities who had made submissions. I don't know if this is the stage at which we do that, but or that if Parliament has had any indication as to when, or if those people will be wishing to present, make some sort of oral presentation. But perhaps we could make a determination. We have a number of submissions now. How is it that we propose to proceed with those?
Let me just inquire whether members have had the opportunity to read through the submissions. Early in the proceedings, I indicated that my ministry, which is piloting the bill, would do a summary would assist the Parliament with a summary of the submissions and to place them in thematic areas. And then we would, as a committee, take a decision on the approach we take, bearing in mind that not every submission will require an oral presentation. What is important is that the points be properly considered by the committee. I recall that there were different views on the matter. Some members were of the view that if we took the decision to call some and not others, it may raise questions, and the committee was invited to seriously consider the approach that we take. I believe that our deliberations would be better assisted after members have spent a little time just looking at the submissions. Already the approach we have taken is to consider the proposed amendments on the different areas. So we began with the Jamaicanization of the Constitution, which among other things included the insertion of the preamble, the revocation of the Imperial Order in Council, and the separating out of what is now the schedule from that to have it published on its own in volume 1 of the revised laws of Jamaica. We looked at the inclusion, and that is not the entirety of the Jamaicanization of the Constitution, but important preliminary steps. We looked at the inclusion of the ECJ within a particular framework, and then we went into the tidying up of the citizenship provisions. So we will be moving now to looking at the office of president. So far, submissions have raised other matters which are slated for the next round, the next phase of the reform process. I know that one of the questions repeatedly raised, which reflected people's nervousness or uncertainty about whether the process would continue. I hope that the information provided in the speech delivered at the opening of the Parliament would help to assuage the fears. We can't speak for a government formed otherwise, but I know that the Jamaica Labour Party formed government remains committed to continuing the phases of constitutional reform. I know that many wonder whether that will happen because of the decade-long interval between the charter and this work. I can only reiterate that Prime Minister Holness has done what his predecessors never did and perhaps were not prepared to do as an indication of the priority that he accords to this matter. He has carved out a special ministry tasked with a focused attention on these reforms. And to the best of my knowledge and to the best of my belief, I can say that a Jamaica Labour Party administration will continue with the work, and the work will also include looking at the other branch of government, which constitutionally is referred to as the judicature, but it's a judicial branch which involves the court. I reiterate that we have a little different approach. We believe that in this kind of constitutional reform, it's important that we look at the administration of justice in Jamaica, because we do not get to a final appeal court unless there is something to appeal from. And we hear the concerns of many Jamaicans about the courts, the trial courts, and the pace at which things done. We also know from the record that significant appropriations of sums have been made towards the judiciary, and perhaps it's the first time that so many things have been done. We acknowledge, however, that more needs to be done, and that is why we are on this journey. We can't do it all at once, and things left unattended for decades will not be solved overnight. But we have a clear path that we are taking. Bumpy the road is, rugged as it is, but the intention of the Holness administration is to continue with the work.
Madam Chair?
Yes.
This may be an opportune time to welcome our guests in the gallery. There are 34 students from the Faculty of Law at Mona.
Thank you, Committee Clerk. I regret that I am at such a distance in the virtual space, but I welcome the students from the Faculty of Law to this committee sitting of the Parliament. Last week, we also had other students, and I used the opportunity then to explain the difference between a sitting of the entire House and a sitting of a committee. So you are in the gallery and you're looking over and you may see empty benches. Well, it's not a sitting of the full Parliament, but a sitting of the committee, and the committee is a small number of parliamentarians from the two houses of Parliament, the appointed Senate and the elected House of Representatives. And it should have members from both sides of the Parliament, but today we only have members of the government side. And this is a hybrid sitting, so members are in person and also online, if there is anyone in person in the chambers. So welcome. We are reviewing the bill that is amending the Constitution, the Independence Constitution, to change the form of government from a constitutional monarchy to a republic, parliamentary republic. And we are retaining the parliamentary cabinet system We are not moving to the executive presidential system, similarly to what obtains in the US. We are also, I'm inviting you, if you have not yet done so, to read the bill. It is publicly available. As students of the law, I invite you to take some time to go through it. If you have any questions, we have created space for you to ask those questions, including through the Ministry of Legal and Constitutional Affairs website and a specific Rotary Republic website. It is not the norm to interact with members who are in the gallery when we are having either a sitting of a committee or of the House and you visit. So you may have questions, but the current rules do not allow for interaction between the gallery and the floor. When we are physically in the Parliament, we usually take the time to slip out and interact with you. But I don't, Madam Clerk, I am not seeing from my screen whether any committee members is physically in the House.
Madam Chair, today all our members are online.
I see, right. But perhaps members of the technical team may wish to interact. I would invite the persons from the Ministry of Legal and Constitutional Affairs, if the students are still present when the committee breaks, please use the opportunity to interact with them. After all, they are aspiring to be where we all are as lawyers, firstly. All right. We can get back to the matter arising. Member Goldie, is there anything else you wish to add?
That's it. That was my only.
Yes. All right. I wish to ask members to consider whether an interim report should go to the Parliament. I will not ask for a decision today, but I am throwing it out, and I will ask members to consider the matter and we can discuss further. You may recall that a few meetings ago, Member Sinclair raised the issue of the implications of members of the opposition agreeing to serve on a committee which the rules require that the committee should be constituted to reflect the balance of the parties represented in the Parliament. That was done, and the opposition has since withdrawn from the process, indicating that they desire to hear from the Prime Minister on the matter of Jamaica's final court. Members may also recall that I pointed out that the government's position was that the matter of the court would be dealt with in the next phase, because there were divided views on which court should be Jamaica's final court. There being three options for consideration: the establishment of a final Jamaican court, which would be a Supreme Court in name and nature, accession to the appellate jurisdiction of the Caribbean Court of Justice, or retention for the time being of the Judicial Committee of the Privy Council. There are pros and cons to each. There are numerous arguments on different sides of the equation. And we are of the view that it would make sense to have a thorough look at the options that are open. After all, we are not legislating only for today. Questions have been raised about the Jamaica Labour Party's relationship with the CCJ. I can only clarify that the Caribbean Court of Justice Jamaica is a member of the court in its original jurisdiction. The court is a court that is used for the resolution of Caribbean community matters. So there should be no misunderstanding in the public's mind about where Jamaica stands in respect of the court. We are a member of the court in its original jurisdiction. The court is a Caribbean community court, and there are matters regarding the revised Treaty of Chaguaramas, which establishes the Caribbean community, that are litigated in that court, and Jamaica participates in it. The appellate jurisdiction is as a separate side of the court. All right, so I am putting on record for members' consideration whether an interim report should be sent to the Parliament. The proposal is a procedurally proper one, but I know that there may be different views on the matter. I'm not going to invite a discussion of it at this time. I'm merely asking members to note it, and then we can discuss at a later stage. That would mean that the other matter would be a continuation of the review of the bill with a discussion on the provisions relating to the office of president. I propose to go no further than to just read through those provisions today, and then we would wrap the business of the committee for today and come back after we have considered the submissions from members of the public to enable the committee to make a determination how we proceed to consider those points. Any response from members? If not, I would invite the Chief Parliamentary Counsel to take us through the clauses related to the president. And there is the major clause is clause 11. We also have clauses 12 and 13, 12, 13, and 14, which deal with consequential amendments that would flow. But I propose that we just begin by going through clause 11, and then we pause after that.
Good morning.
Madam CPC, may I invite you to take us through clause 11?
Yes, good morning. Clause 11, amendments to Chapter 4 of the Constitution. Chapter 4 of the Constitution is amended by A, deleting the subheading, the Governor General, and substituting, therefore, the subheading, the President. B, repealing Section 27 and inserting next after the subheading the following sections. 24, Office of President. 1, there shall be a President of Jamaica who shall A, be the formal head of state of Jamaica, and B, perform the functions assigned to the President by this Constitution or any other law. 2, a person shall not be qualified to be appointed as President unless the person A, is a citizen of Jamaica, whether by birth or descent, B, has been ordinarily resident in Jamaica for a period of at least 10 of the 15 years immediately preceding the date of the person's nomination for appointment under this section, and C, is not disqualified for membership of the House of Representatives or the Senate as described in section 40, subsection 1 and 2. 3, for the purposes of paragraph 2A, that should be subsection 2A, by descent means by virtue of having a parent or grandparent who is a citizen of Jamaica by birth.
May I just invite a pause, Madam CPC, just for those who have been following the proceedings. It's this proposed provision that helped to inform some of the discussion last week on whether there should be a limitation to the degree by which Jamaican citizenship can be acquired by descent. Please proceed.
For appointment of president. 1, a vacancy in the office of president shall be filled by an appointment made in accordance with this section. 2, the Prime Minister shall consult with the Leader of the Opposition on the nomination of a person qualified under section 24(2) for appointment as president. 3, on a consultation under subsection 2, all reasonable steps shall be taken by the Prime Minister and the Leader of the Opposition to agree on the nomination. 4, for the purposes of subsection 3, A, the Prime Minister shall recommend a nominee to the Leader of the Opposition for consideration. B, if the Leader of the Opposition agrees with a recommendation under paragraph A or C 1 or 2 for a nominee, 1, the Leader of the Opposition shall so inform the Prime Minister. 2, the Prime Minister shall in writing inform the Speaker and the Senate President as to the nominee. And 3, the Speaker and the Senate President shall refer the nomination to Parliament for a confirmation vote. C, if the Leader of the Opposition does not agree with the recommendation, the Leader of the Opposition shall so inform the Prime Minister, and the Prime Minister may, 1, refer the recommendation back to the Leader of the Opposition for reconsideration, or 2, recommend a different nominee to the Leader of the Opposition for consideration. D, in any case where a recommendation is referred back to the Leader of the Opposition for reconsideration, the Leader of the Opposition may propose a different nominee. And if the Prime Minister, 1, agrees with the proposal for a different nominee, the Prime Minister shall in writing inform the Speaker and the Senate President as to the nominee, and the Speaker and the Senate President shall refer the nomination to Parliament for a confirmation vote. Or 2, does not agree with the proposal, and not less than 3 months has elapsed since the Prime Minister first made a recommendation to the Leader of the Opposition in respect of a nominee to fill the vacancy, A, the Prime Minister shall determine the nominee, and after informing the Leader of the Opposition as to the nominee, in writing inform the Speaker and the Senate President as to the nominee. And B, the Speaker and the Senate President shall refer the nomination to Parliament for a confirmation vote. 5, the nomination referred to Parliament under subsection 4 shall be put to a confirmation vote conducted by a secret ballot at a joint sitting of the Houses of Parliament. 6, on a confirmation vote under subsection 5, the nominee shall be appointed as president if the nomination secures the vote of each House by a majority of all its members voting pursuant to subsection 5. 26, tenure of office of president.
May I just invite a pause there? Now, I am aware that this provision has been the subject of much discussion in places of interest. Just to point out, even before we proceed to consider submissions on the matter, that the appointment process is two-stage. It's a two-stage process. It involves a nomination process and a confirmation process. The power to nominate is given to the Prime Minister, and that power is exercisable after consultation with the Leader of the Opposition. The Leader of the Opposition is given a power to recommend a nominee for consideration, but the confirmation would be done by the Prime Minister. Now, we are taking keynote of questions around this power being given to the Prime Minister, the role of the leader of the opposition, and also on the confirmation side, the vote to confirm. Just to say that the proposal, just to remind, firstly, that what has found its way in the bill has varied from the recommendation of the Constitutional Reform Committee that is contained in the report that was tabled in Parliament. And the revision came as a result of response by the committee to the feedback received from the public. We note that the discussion continues. The reason why my ministry spent some time making a presentation on the parliamentary cabinet system and the executive presidential system is to help everyone who's paying attention to understand the differences in the systems and the essence of the parliamentary cabinet system. I do not expect that the knowledge gap is going to be closed by a single presentation. I'm very aware that there are many persons who have never paid close attention to this matter, that they don't fully understand it. And especially since, you know, it is not a matter that is taught in schools. So there are certain consequences that flow from general elections in a representative democracy. It's not a direct democracy. We elect representatives who have specific roles and functions. And things flow from that. So it is, when we speak of a power being given to the Prime Minister, it is whomever holds the office of Prime Minister. When we speak about powers given to a leader of opposition, it's without regard to who is the current or future holder. It's to the office as constituted. I realize that some people think that when we refer to a prime minister or a president, we're limiting, a prime minister or leader of the opposition, we're limiting it to current holders of the office. Not so, because laws continue to speak over time. Constitutions speak over time. In respect of the vote, the only comment I will make at this time, because I know the committee will have to give detailed consideration, is that it's not the intention in a parliamentary cabinet system to provide a veto to the opposition on the matter of the selection of a formal head of state who is not involved in the day-to-day running of government. So the non-executive president is not the head of government. It's the head of state, discharging very important functions, but those functions do not involve the day-to-day running of government. The day-to-day running of government is reserved for those who are duly elected through the democratic process. All right, those are my brief comments at this time. I don't know if any member of the committee has any comment that you wish to add.
Chair, I would just, I know the sections that have been amended and the sections that it's being proposed are to be repealed from what exists currently. I would just remind us though that over the last, I would say 15 years or so, we have empowered the head of state in the form of the Queen's representative, the Governor General, with some very significant and critical responsibilities that have to do, I don't know that it is really 100% correct to say with the running of government, because those functions have to do with the operations of critical statutory bodies. Certainly the appointments of statutory bodies is a critical function. And so I'm cautious in saying that. Yes, it's not a day-to-day operational matter, but it is certainly an extremely important one. So the Governor General is no longer just a ceremonial head of state or representative of the head of state. He has a role in how we construct our public bodies. The other thing I would say, but just for clarity, Chair, you say you were going as far as what? Which clause?
Just clause 11 today, we
Just
would
clause 11.
read
Okay.
through today. Yes.
Okay. So in relation to clause 11, I note that clause 11, and I believe it is clause 11. Let me just double check. Yes. I note that clause 11 repeals section 30 of our current constitution, which provides for a governor general. Well, the marginal note is a deputy governor general. Someone to act in the position of the governor general when he's away from Jamaica and some other matters. And I'm just raising this for the committee's consideration because this process of appointment that is proposed here, and I am understanding it to be that we would not have a deputy governor general. But this process of appointment is a rather lengthy one, so that if there is not agreement between the leader of the opposition and the prime minister, that inability to reach consensus must extend for 3 months before there can be any action taken to refer the matter to the parliament. And I just raise whether or not, if we, in the event that there is a vacancy in the office, if that length of time would serve us if we were not to have someone in place. And I note, I'm trying to see what not recalling our provisions proposed here for someone to act in the office if the substantive holder of the office were to vacate the office. So I'd be grateful for the CPC's opinion on that matter.
Thank you, Member Golden. You are correct to say that currently our de facto head of state, the Governor General, has powers that are not merely ceremonial. Our model moved past that some decades ago. It's not mere ceremonial power, but you may recall that I was at pain to point out how unfortunate it is that we have cheapened ceremony and people now scoff at it and think of it as emptiness. My own view is that for the years of economic decline in this nation, when the economy was poorly managed or mismanaged and growth was in the decline, ceremony took on a different nature, perhaps to just appease people. And over time, people view it as empty because numerous ceremonial events were held with announcements that never materialized to anything. I recall, announcements made, government will do this, government will do that, when no monies were identified for the projects being announced. And over time, people have understandably and rightly grown cynical about ceremony, because ceremonial matters have been cheapened in Jamaica over many years, a direct consequence of our economic mismanagement of the nation, and an attempt to give a feel-good atmosphere to people when they ask for serious matters to be addressed. But I hope that coming out of this process, we will help Jamaicans and everyone to understand that there is a proper place for ceremony, because it marks an important occasion. So, for example, a ceremonial opening of Parliament marks the start of a parliamentary year, which then begins essentially with a presentation of the agenda of the government, and also a reminder of what has been done in the past. We have to pass a budget first and foremost before we can do anything in a new parliamentary year. And there is an important ceremony to cause everyone to pause and take notice that something important is happening. Having said that, though, I took great care with my words. So my use of the day-to-day running of government was deliberate, because that is important. But your point about the consequence of the power given to the Governor General to make appointments is an important point. Historically, the Governor General had responsibility for the appointment of the civil service and also for important public offices. That power has been delegated in many cases, but the delegation of a power does not preclude the exercise of that power by the person in whom it is vested. But we have seen our civil service and our public service taking on features that make citizens question in whose interest decisions are taken. That is something that we will have to look at in earnest. But you are correct that where the Governor General is given a power, using the Governor General as the head of state, that power would also be given to the President. And it relates to appointments of important office holders. Consequences flow. I think, however, that it's important for everyone to understand that in building a nation and in building institutions, we have to set aside a place where the cut and thrust of partisan politics are kept out of institutions. And this is not to say that those who are given roles and functions should disregard what the priorities of a government are. We have a lot to understand. When a government is formed after elections, the government has the authority to pursue policies, to pass laws, and to do things that it committed to do on a campaign platform, matters that are contained in its party manifesto. And, in another place and another time, we will have to help to educate Jamaicans about this and the connection to the parliament, to the cabinet, to having a prime minister in place, to having ministers of government, to having members of parliament who are legislators. So your points are noted, but it is still important that everyone understands that the day-to-day running of government is reserved to the elected officials. However, government is not just the political directorate. So when the term government is used, it is used in different contexts. In some occasion, it refers to the political directorate, but then there is an entire machinery of government comprising civil servants and public servants who administer the policies of government, who have very important roles and functions, and how the functions are performed, how powers are exercised, impact greatly what a political directorate sets out to do, forming government. But I think as we went through the submissions from members of the public during the Constitutional Reform Committee phase, we recognized that because some people were calling for an executive president, other issues came in the crosshair of that call. And in the minds of many, they did not separate out how some of the things they were asking for related to the executive presidential system as opposed to a parliamentary cabinet system. On the other matter of the process, and whether provision is being made for someone to perform the functions of president when the president is unable to perform those functions, you will see that those matters are set out. We have not formally provided for a deputy president, but at no time would the office of president be left vacant without someone being able to discharge the functions of office. When we go through, you will see how that matter is provided for in different scenarios. All right?
Madam Chair?
Yes.
Member Morrison has her hand raised.
Yes. Member Morrison?
Thank you, Madam Chair. I just want to point out that it is very interesting, even though we are on the same path, sometimes look things in through different lens. And my colleague, Senator Golden Campbell, she raised, I wouldn't even say that she's looking at an issue about the lengthy process or the duration, right? It's what, maybe up to 3 months? Is that Senator Golden Campbell? Right? I maybe need to revisit the length of time that this process takes in selecting the appointment of the president. But interestingly, Madam Chair, I noted when I read that aspect of it, the thorough or the rigorous steps that were being taken to ensure that the process is one, transparent, two, not prejudiced, I'd say three, even one of rectitude. It doesn't come across as being rushed or done out of expediency, and certainly showing respect and regard of the leader of the opposition. And Madam Chair, that you were very careful making the point that it is not about the person who is the leader of the opposition, but actually the office. So as it pertains this aspect of it, I am satisfied. I am not going to weigh in on the length of time, but what I appreciate with it are the different steps in the process that ensures that when the final decision would have been made, it would have been one that was done out of consultation and regard for the office of the leader of the opposition. Thanks.
Member Morrison, thank you so much for those observations. You were not part of the Constitutional Reform Committee, but I'm very pleased to hear that you were able to understand those provisions. So two things that we deliberated on. the difference between consensus and consultation. So there is a section of the public asking for consensus. When you require consensus, in the absence of consensus, the side, whomever is not agreeing, is effectively vetoing. It's an effective veto provision. So that one of the downsides of the executive presidential system is how often it goes into gridlock, bringing things to a grinding halt. For those who do not have to actually administer government, they may view that as a good thing because it provides good spectacle. But when you need to get things done and get things done in a timely way, you understand that gridlock can deal a difficult blow to the business of the people. So the process is designed to ensure meaningful consultation. And as you rightly said, that it is not rushed, that it is not superficial, that it does allow for time for back and forth, for reference back if need be. So the design of the system is to facilitate meaningful consultation because the power to nominate is exercisable after consultation. And we take into account different scenarios from the reality of what obtains now, because it would be a loss to us if we did not assess how things were currently. May I just ask for a slight pause, just to address something online? I will just go off mic and off video briefly. I'm just doing an audio check. Am I being heard?
Yes, you are, Chair.
Just a minute. Let me... Mic check. Madam Chair?
Hear you, Chair. Hearing you.
Oh, thank you. Thank you. Good.
Chair, I
Yes.
just want to follow in on the intervention that I just made. And I think I remain with the difficulty in terms of the length of time. And I appreciate that the question of consultation and at subclause 3 of clause 25, reasonable steps, the requirement for the Prime Minister to take reasonable steps to consult with the leader of opposition has been defined. However, Chair, one moment, please. My device is moving to. A moment, please. Apologies, Chair, apologies. Are you hearing me?
I'm hearing you. Member
No,
Golding.
so I was saying, subclause 3 of clause 25 requires the Prime Minister to take reasonable steps to consult with the leader of the opposition. And we have outlined in subclause 4 what we mean by reasonable steps. That process requires a minimum of 3 months. My concern about the repealing of Section 30 of the Constitution, which currently provides for a person to act in the absence of the Governor General, I don't feel is really, I don't have any comfort, and I'm guided if I ought to have better comfort. Because when I look at the amendment being proposed to Section 29 of the Constitution, which is the provision for an acting Governor General, what we have said is that when the Prime Minister, when the President is temporarily, and I emphasize that word, incapable of performing functions of the office because of absence from Jamaica, illness, or any other cause, the Prime Minister can consult with the Leader of Opposition, and Prime Minister must consult with the Leader of Opposition and appoint a custos or a member of the President's Council to it's essentially act. The difficulty that I'm having, Chair, is that this is in this situation where I don't see that this applies in the situation where the office is vacant. So if the President has vacated the office, whether by resignation or by death, that is not being temporarily incapable of performing the functions of the office. That is a permanent incapacity to perform the functions. And that doesn't allow for the Prime Minister to consult and appoint an acting member for the period that it takes for an appointment of a new president to be completed. So I am suggesting there may be a gap, and I'm happy to be guided to see where that gap is closed.
All right. So there is provision for temporary absence. There is also provision for when the office is vacated, and there is provision for an interim president. As we go through the provision, we will consider whether there is any gap. But may I just ask that we go through those provisions and then we can come back to the matter. I have noted the points that you have raised.
Very well.
All right. I had merely paused just to indicate not only to members of the committee, but to those who are viewing online, that we have taken account of the commentary. We are listening very closely to the feedback being provided, and we want to explain to you the rationale for what is in the bill. It doesn't mean that we will not accept any improvement that will inure to the benefit of the overall system. But there is a good reason. There is a solid reason for the proposals as they are, even as we pay attention to the feedback from those who have taken the time to comment on the process. Right? When you ask for agreement, and I've moved away from the point of filling the vacancy because that is a separate issue. I just wanted to go back to the point about whether it should be by agreement or after consultation. If you say that a decision can only be taken by agreement and someone is bent on disagreeing, then you are going to entirely frustrate or prevent the exercise of that function or that power, and we have to be careful about that. We also need to understand the difference between the executive presidential form of government and the parliamentary cabinet system, because in the parliamentary cabinet system, there is a separate head of state and head of government. In the executive presidential system, one office holder is both head of state and head of government. So politics, affairs of state, affairs of government, everything is mixed up in one. As we listened to Jamaicans, we interpreted the views, the questions asked, the expressions of doubt, as saying that there is a proper place to separate the state of Jamaica from the day-to-day running of Jamaica, which is deeply connected to the partisan competitive politics. All right, let us continue with the provision, and then we will come back and consider whether there are gaps, whether there are matters for further clarity. But thank you both for sharing your views on the provision so far. Madam CPC?
26, tenure of office of president. 1, subject to the provisions of this section, a person appointed as president shall hold office as president for a term of 7 years and is eligible to be reappointed in the manner specified in subsection 2 for such further term not exceeding 5 years as shall be specified in the instrument of reappointment. 2, the question of reappointment of a person who holds office of president shall be determined within the period of 1 year immediately preceding the expiration of the person's first term as president by the procedure of a nomination and confirmation vote conducted in the same manner as a nomination and confirmation vote under section 25. 3, the holder of the office of president may at any time resign the office by tendering the resignation in writing to the Prime Minister, who, A, shall in writing notify the Speaker and the Senate President of the resignation, and B, may act under Section 25 or subsection 14 to fill the vacancy caused by the resignation, whether or not the sitting referred to under subsection 4 has occurred. 4, upon being notified of the resignation pursuant to subsection 3, the Speaker and the Senate President shall cause a joint sitting of the Houses to be convened for the purpose of accepting the resignation. 5, at any time during the President's term in office, the President may be removed from office on any ground specified in subsection 6 in accordance with the procedure set out in subsection 7. 6, the grounds on which the President may be removed from office are that the President, A, is unable to perform the functions of the office, whether arising from infirmity of mind or body or from any other cause. B, has behaved or is behaving in a manner that endangers the security of Jamaica. C, has behaved or is behaving in a manner that brings the office of president into disrepute. Or D, is, by that person's own act, under a duty of allegiance, obedience, or adherence to a foreign power or state. 7, the question of whether the President should be removed from office on any ground specified in subsection 6 may be put to Parliament only upon the motion of the member of the House of Representatives who is responsible for leading the business of the government under the standing orders of that House, tabled at a joint sitting of both Houses and setting out A, the ground relied on, B, the proposed members of the investigatory panel to be established pursuant to subsection 8, and naming the member who will be the chairperson of the panel, and C, the time within which the investigatory panel shall submit the report required under subsection 8, which shall not in any event exceed 6 months from the date on which the investigatory panel is constituted under subsection 8. 8, if a motion tabled under subsection 7 is carried by a 2/3 majority of all the members of each House of Parliament, voting by secret ballot at a joint sitting of the Houses, an investigatory panel shall be established to investigate the question of whether the President should be removed from office, and the chairperson of that panel shall, at the conclusion of its investigation, submit a report of the panel's findings and recommendations thereon to Parliament, including a statement as to whether or not the ground relied on or any other ground has been made out to the panel's satisfaction. 9, before submitting the report to Parliament under subsection 8, the chairperson of the investigatory panel shall A, give a copy of the report to the President and afford the President the opportunity to respond thereto within such time as shall be specified by the investigatory panel in writing accompanying the copy of the report, and B, make such adjustments to the report as the investigatory panel considers warranted as a result of the response, if any, provided by the President. 10. For the purposes of subsection 8, A, the investigatory panel shall consist of 3 members, being persons who hold, have held, or are qualified to hold office as a judge of a court having unlimited jurisdiction in civil and criminal matters, whether in Jamaica or elsewhere, or a court having jurisdiction in appeals from any such court. B, the investigatory panel may direct its own procedure, call for evidence, and summon and hear witnesses. And C, the chairperson of the investigatory panel shall submit the panel's report to Parliament by giving a copy of the report to the Speaker and to the Senate President. 11. The time set out under subsection 7C, within which the chairperson of the investigatory panel shall submit the panel's report to Parliament, may be extended by Parliament to such further period not exceeding 6 months, A, on the written application of the chairperson of the panel, accompanied by an interim report on its investigation, and B, by a resolution initiated by the member of the House of Representatives who is responsible for leading the business of the government under the standing orders of that House, and approved by a majority of all the members of each House of Parliament voting by secret ballot at a joint sitting of the Houses. 12. The proceedings of the investigatory panel shall not be invalidated by any defect in its composition due to the incapacity of any of its members by reason of infirmity, death, or any other cause. 13.
May I just pause to say that this particular provision has taken into account problems that we have experienced where panels have been rendered almost incapable of completing its work because a member has died and the work has to start all over again. We have a current situation that we're working with. So those who have looked at the bill through comparative lens pointed out this provision as one of the good innovation they thought been included in it. We'll come back to it. Thank you, Madam CPC. Please proceed.
Speaker and the Senate President shall cause the reports of the investigatory panel to be tabled at a joint sitting of both houses, and in any case where the report states that the ground relied on or any other ground has been made out to the satisfaction of the panel, A, Parliament shall vote by secret ballot at a joint sitting of the Houses on the question of whether or not to remove the President from office, and B, if each House by a 2/3 majority of all its members votes that the President should be removed from office, the office of President is vacated. 14. Where the office of President is vacated pursuant to subsection 13, an interim President appointed by the Prime Minister after consultation with the Leader of the Opposition shall carry out the functions of the office until a President is appointed in accordance with section 25. And if I could just pause there, because this is a provision that would address the concern raised by Member Golding Campbell. So this would allow for the appointment of an interim president in a case where the office is vacated. However, we had a provision in subsection 3 that provided for the Prime Minister to act to fill the vacancy under created by a resignation by acting under subsection 14. So it would also apply in that case. I'm suggesting, therefore, that we need a slight amendment here, where it says where the office of President is vacated pursuant to subsection 13, it should really be where the office of President is vacated pursuant to this section. Right. So that, because it covers both cases of subsection 13 and a resignation under subsection 3. Yeah. Subsection
Thank you.
3. Yes.
Thank you, Madam CPC. I already noted that this section would have to be tweaked because the intention was not captured by the reference to subsection 13. So you and I are exactly on the same point, that instead of subsection 13, it would be pursuant to this section. Thank you. Senator Campbell, Golden Campbell, then this...
Gap closed, Chair, gap closed.
Yes. Wonderful. Good. Please proceed.
An investigation or any proceeding in Parliament is carried on pursuant to this section shall not preclude the exercise by the President of any of the functions of the office of President. 27, immunity. 1. A person holding the office of President or exercising the functions of that office under any provision of this Constitution shall not be liable in any criminal or civil proceedings for A. Any act done in respect of those functions, or B. While in office or exercising the functions of the office, any act not involving treason, violence, or fraud. 2. No form of summons, warrant, or other legal process shall be issued or executed against a person who holds office of President during that person's tenure in office, and the period in which any such process cannot be issued or executed because of this subsection shall not be taken into account for the purpose of any limitation period applicable to the legal proceedings to which the process relates. C. By repealing Section 28 and substituting therefore the following. 28, oath to be taken by President. A person appointed to the office of President shall, before entering upon the duties of that office, take and subscribe an oath administered by the Chief Justice in the form of the oath of allegiance set out in the first schedule. D, in Section 29 by 1, deleting subsection 1 and substituting therefore the following. 1. Whenever the Prime Minister is satisfied that the President is temporarily incapable of performing the functions of that office by reason of absence from Jamaica, illness, or any other cause, the Prime Minister, after consultation with the Leader of the Opposition, shall appoint a custos or a member of the President's Council to carry out the functions of the President during the period of the incapacity. And 2, deleting the word Governor General wherever it appears, including in the marginal note, and substituting therefore in each case the word President. And C.
Madam Chair, can I just interrupt the CPC at that
Yes.
point? I would just ask, can you shed some light on the rationale behind the different appointment process in terms of where the president is absent or ill versus where the president has vacated the office? In the latter case, the Prime Minister, after consultation, appoints an interim president. And in the former case, for reasons of illness or absence from the country, it is the custos or a member of the council that the Prime Minister appoints after consultation with the Leader of Opposition. Why have we made a distinction there?
May I assist before the CPC weighs in? Good point, Senator Golding. No, a vacancy in the office may arise suddenly, so that illness can be unpredictable. Someone may go out, fall ill. The intention is to ensure that at all times, someone is able to carry on the functions of the office of President. But we also, so the quick fill-in, quick process is designed to take care of that. Who would do it for a short period? Those are identified. That is contrasted from a situation where the office is vacated after a process. A resignation can also be sudden for any of many reasons. So we have sought to make provisions for an office being vacated after going through a process, which requires another process for the filling, or where there is need to immediately have someone in to perform the functions of office. And then you don't have to be guessing and spelling from where you can draw that person to fill the office temporarily. Because if the office is vacated temporarily, you would still have to go through the process of appointing someone permanently. But that process would take time because it's the two-stage process of nomination, and the nomination process requires meaningful consultation and then confirmation by the Parliament. You wouldn't want the office to be vacant while that process is taking place.
Well, I'm still not a little confused. the process for appointing a president to act or appointing someone to act in the office of president for reasons that the president has resigned suddenly. What is the provision for that? What's the process for that?
So a resignation would mean that the office becomes fully vacant. It's not temporarily vacant. And then you would need a new full-time office holder. That is separate and apart from a person being incapable of performing the functions of office because the person is ill or the person has to be out of Jamaica.
Right.
Or any other related reason.
Right.
So if someone resigns from office, you know, a resignation yields a vacancy in the office if they resign. Yes.
I'm agreeing with you.
And then under the system, in order to get to the office of president, you have to go through a two-stage process of being nominated, and there are rules around the nomination, and then being confirmed by the parliament.
So I'm asking then, why is there a difference in who the prime minister can nominate in that scenario as opposed to who he can nominate in the situation where the office holder is ill and temporarily absent? Why is it that if
one allows for a wider consideration to fill the vacancy in a permanent way, and one allows for a shortened process that would allow the functions of office to be carried out? So it was almost a kind of a resort to a default position or a familiar position of what we have now, where the custodies are the ones from whom the selection is done to fill a vacancy. Not that it's the only choice that can be made, but if you notice, for example, on the last state opening of Parliament, the Governor General was unable to perform the functions because I think it was said he was recovering. And it is the senior custodian who did that, who I think was placed in the position of Deputy Governor General.
Here, I don't know that my question is answered, and I'm sorry.
So you're saying, why do you not specify the person, the category of persons that you can consider from?
No.
Either to specify it in both cases or to leave it open?
Here, let me ask the question. The question is, you have provided for the appointment of a custodian or member of the council in a temporary absence. Why isn't that the method of appointment of an interim president in the scenario of the president's vacating the office? Why is there a difference? I don't see that either of them is quicker than the other. In fact, I would suggest that the appointment of a custos is probably quicker than identifying someone outside of the custody group. So this interim president, the prime minister, I suppose, could fill the vacancy in the interim from the custodies, but we're here saying that an interim president is appointed by the prime minister after consultation, and there is not that restriction to the group of custodies or the president's council. And I'm trying to understand why, if this person is simply an interim president, which, I mean, that same 3-month time that could elapse before the office is permanently filled could very well elapse as a function of illness. So what's the justification for it being this way under vacancy and the custody way on temporary absence?
Madam Chair?
So, yes.
Madam, if I could assist, maybe perhaps the reasoning was that in this case there's a vacancy, so this sort of selection would allow for a choice from a wider field. And so it might very well be that ultimately that person could end up being the agreed candidate.
Okay, and that was going to be my follow-up question.
Yes. That was a consideration, Senator Golding. Yes. All right. Good, thank you. Proceed.
Right.
12.
Right, so we're at the final E by repealing section 30. Are we going on to 12 or
Yes,
are we
12,
not?
12, 12 and 13 very quickly.
Well,
I
12 is
think
just a
they're kind of
tidying up.
self-evident. Yes.
Yes, it's a tidying up of references. Essentially, it's just replacing wherever the term president, which refers now to the president of the Senate, appears in the Constitution. It's being substituted with the term Senate president. Subsection 2 amends Section 42 by repealing subsection 2 and substituting therefore the following. 2. Upon the election of the Senate President and before the Senate President enters upon the duties of the office, the Senate President shall, unless the Senate President has already done so in accordance with the provisions of Section 62, make and subscribe before the Senate the oath of allegiance set out in the first schedule. 3, Section 137 of the Constitution is amended, A, in subsection 1A, by deleting the words President or Deputy President of the Senate and substituting therefore the words Senate President or Deputy Senate President. B, in subsection 3, by deleting the words 1, Office of President, and substituting therefore the words Office of Senate President, and 2, Deputy President, and substituting therefore the words Deputy Senate President. 4, references in any other law to the President of the Senate shall be construed as references to the Senate President elected under Section 42 of the Constitution. And then 13, tidies up the references to Governor General by replacing them in the relevant sections with the word President.
I think it may be a convenient time to take the pause. We will have to right. I think we just have to do a little bit of work as we come back to look on the section. Ms. Wilkins, do you have a point you wish to make publicly? Or we can wait until we come back at the next meeting? All right.
Yeah, we can wait. I will discuss it internally, and then we can determine what is appropriate.
All right. So just for the benefit, to allow others to benefit from what you have said, we're just discussing some of the points raised a short while ago on the section. We, as the ministry, piloting the bill, will look back on any matter that needs to be closed and to make sure there are no gaps. All right.
Chair, before you close, I just want to ask this question, not for response now, but for the next occasion. In relation to the office of the president or even the office of the current governor general, how is that office constituted in terms of the positions in that office? What is it that provides for that? Is it the general public service establishment system? How is it identified that the governor general needs what functions in order to operate? And what is the contemplation for that in terms of the amendments we're making, given that we have removed this concept of the deputy governor general or deputy president? It would be, what does that look like? I'm not suggesting that that's necessarily something enshrined in the Constitution, but I would wish to be guided and advised in relation to that on the next occasion.
Just quickly to say, Senator Golding, that the provision is that on the establishment of the office, the person shall perform the functions assigned to the president by the Constitution or any other law. so broadly speaking, and that is what currently obtains in Jamaica. The head of state performs functions assigned by virtue of the Constitution or any other law. That is not changing. We had a special subcommittee of the Constitutional Reform Committee that looked at all of the functions performed by the Office of Governor General for a determination to be made with a recommendation about what functions are to be performed by the Office of President. And the decision was taken that substantially what is done by the Governor General at this time would be done by the President, bearing in mind that we had moved away from a strict ceremonial President, Governor General, when very important functions were vested in the office around appointments to sensitive office and other matters. The other part of it, how is the office constituted? So if you look at the provision which says that it's chapter 4 of the Constitution now, which says that there shall be a Governor General of Jamaica who shall be appointed by Her Majesty and shall hold office during Her Majesty's pleasure, and who shall be Her Majesty's representative in Jamaica. So that is a provision. The appointment is done by the King. No, the conventions around that is that the recommendations for the office holder comes from the Prime Minister. And I think that is after consultation with the leader of the opposition. So that is the convention right now. So we have maintained a nomination process because though it is not set out in section 27, whomever holds office is usually nominated by convention. This is not to say that the monarch may not take on to himself the power to impose someone for as long as we have the constitutional monarchy as our form of government. But by convention, it has operated in a particular way. And well, we haven't had a change of Governor General since we have had a change of monarch. And remember, Queen Elizabeth II was in office pre-independence, on independence, and up until recently. So we really don't know how King Charles III would operate, though my suspicion is that it would be in keeping with the existing conventions. If your question had another part about the staff of the Office of Governor General, then that's a separate matter that is to be dealt with.
That was actually
Yes.
my question. And I know that we provide in the Constitution for Parliament to prescribe the office, the Constitution of his office. And are we keeping that provision?
Well, we're grateful to the Office of the Governor General, and in particular to the Governor General himself for the assistance provided to the committee in gaining an understanding of how the office operates. Suffice it to say that we will have to look at resourcing and constituting this office in a different way, in an improved way going forward. It remains a sore point. There are a number of issues around the resourcing of the office, which shouldn't be, and it is my hope that sooner than later they will be resolved, but certainly they must be resolved before these reforms take effect.
And the very last one, Chair, I don't know if CPC could guide me. The currently, what act of Parliament is it that prescribes the offices that are to constitute the staff of the GG?
Well, there is a provision in the Constitution itself, but there is also a specific act that deals with the Governor General, you know.
Yeah, that's what I'm asking. Yes. I don't know if you could. tell me
I'm
that
not
off
quite
the top.
recalling the name, but it's something like the Governor General Staffing and Pensions Act,
Yes.
something. But
Thank you.
yes, but 31 of the Constitution, which is retained, is what provides for the personal staff of the Governor General to be prescribed by Parliament.
Yes, thank you so much.
All right. I think this is as far as we will go today. No, I believe next week we go into Standing Finance Committee, Wednesday, Thursday, Friday. So we will not be able to meet next week. So we will set our next meeting for the following week. And in between now and then, we will send out some information to the committee through the committee clerk. Madam Clerk, just remind me where we are with the matrix.
The research section at the Houses of Parliament had in fact prepared a matrix, and it was circulated. It was circulated, I believe, last week, and an updated version was circulated this week and recirculated yesterday. So members of the committee would have the matrix, but it may require some revision. I am not sure about that, but at present, the document in its current form is with the members of the committee and the technical team.
Is that the same matrix, Madam Chair, that's not the same as you were referring to in terms of the submissions and the support of your office to create a summary of those submissions?
All right, here is how I will answer you, Senator Golden, that we will have some time between today's meeting and our next meeting, since we will.
You're muted, Madam Chair.
I'm sorry, I was saying that we will have some time between today's meeting and our next meeting, since next week will be taken up with the meeting of the Standing Finance Committee. So we will look at what has been circulated and provide assistance to the committee. Just to ask and to really say to the teams, the technical teams working, let us try as far as possible to get the documents out days before the meeting. Senator Golden expressed her concern about just getting the document the night before. And I share the concern, because time has to be allocated to prepare for the meetings of the committee. And if the documents come the night before, the time may not be enough to allow members to read through and do the required preparation. All right? So if there is no other business, I am proposing that the date and time of our next meeting would be, what is Wednesday afternoon? What's the date?
It would be Wednesday, January 12th. I'm sorry,
Yes.
March 12th.
All right. Wednesday, March 12th. And let us also put the 13th, if possible, 12 and 13. Wednesday and Thursday. Because we really want to wrap up this work as quickly as possible. Fine. I will take my previous remarks as my closing remarks about what is to be done, and the date and time of the next meetings, March 12 and 13. It's now 12:23. Will someone move for the adjournment of this meeting?
So moved, Madam Chair.
Thank you.
Seconded.
Very well. Meeting stands adjourned.